Book 4, Health, Safety, and Social Welfare Benefits. Title 1, Medical, Dental, and Occupational Safety. Chapter 1, Medical and Dental Services. 162, First Aid Treatment. Every employer shall keep in his establishment such first aid medicines and equipment as the nature and conditions of work may require, in accordance with such regulations as the Department of Labor and Employment shall prescribe. The employer shall take steps for the training of a sufficient number of employees in first aid treatment. 163. Emergency medical and dental services. It shall be the duty of every employer to furnish his employees in any locality with free medical and dental attendance and facilities consisting of a. The services of a full-time registered nurse when the number of employees exceeds 50 but not more than 200, except when the employer does not maintain hazardous workplaces, in which case the services of a graduate first aider shall be provided for the protection of workers where no registered nurse is available. The Secretary of Labor and Employment shall provide by appropriate regulations the services that shall be required where the number of employees does not exceed 50 and shall determine by appropriate order hazardous workplaces for purposes of this article. B. The services of a full-time registered nurse, a part-time physician and dentist, and an emergency clinic when the number of employees exceeds 200 but not more than 300, and C. The services of a full-time physician, dentist, and a full-time registered nurse, as well as a dental clinic and an infirmary or emergency hospital with one bed capacity for every 100 employees when the number of employees exceeds 300. In cases of hazardous workplaces, no employer shall engage the services of a physician or a dentist who cannot stay in the premises of the establishment for at least 2 hours, in the case of those engaged on part-time basis, and not less than 8 hours in the case of those employed on full-time basis. Where the undertaking is non-hazardous in nature, the physician and dentist may be engaged on retainer basis, subject to such regulations as the Secretary of Labor and Employment may prescribe to ensure immediate availability of medical and dental treatment and attendance in case of emergency. 164. When emergency hospital not required, the requirement for an emergency hospital or dental clinic shall not be applicable in case there is a hospital or dental clinic which is accessible from the employer's establishment and he makes arrangement for the reservation therein of the necessary beds and dental facilities for the use of his employees. 165. Health Program. The physician engaged by an employer shall, in addition to his duties under this chapter, develop and implement a comprehensive occupational health program for the benefit of the employees of his employer. 166. Qualifications of health personnel. The physicians, dentists, and nurses employed by employers pursuant to this chapter shall have the necessary training in industrial medicine and occupational safety and health. The Secretary of Labor and Employment, in consultation with industrial, medical, and occupational safety and health associations, shall establish the qualifications, criteria, and conditions of employment of such health personnel. 167. Assistance of employer. It shall be the duty of any employer to provide all the necessary assistance to ensure the adequate and immediate medical and dental attendance and treatment to an injured or sick employee in case of emergency. Chapter 2. Occupational Health and Safety. 168. Safety and Health Standards. The Secretary of Labor and Employment shall, by appropriate orders, set and enforce mandatory occupational safety and health standards to eliminate or reduce occupational safety and health standards in all workplaces and institute new and update existing programs to ensure safe and healthful working conditions in all places of employment. 169. Research. It shall be the responsibility of the Department of Labor and Employment to conduct continuing studies and research to develop innovative methods, techniques, and approaches for dealing with occupational safety and health problems, to discover latent diseases by establishing causal connections between diseases and work and environmental conditions, and to develop medical criteria which will assure insofar as practicable that no employee will suffer impairment or diminution in health, functional capacity, or life expectancy as a result of his work and working conditions. 170. Training programs. The Department of Labor and Employment shall develop and implement training programs to increase the number and competence of personnel in the field of occupational safety and industrial health. 171. Administration of Safety and Health Laws. A. solely responsible for the administration and enforcement of occupational safety and health laws, regulations, and standards in all establishments and workplaces wherever they may be located. However, chartered cities may be allowed to conduct industrial safety inspections of establishments within their respective jurisdictions where they have adequate facilities and competent personnel for the purpose as determined by the Department of Labor and Employment and subject to national standards established by the latter. B. A Secretary of Labor and Employment may, through appropriate regulations, collect reasonable fees for the inspection of steam boilers, pressure vessels, and pipings and electrical installations, the test and approval for safe use of materials, equipment, and other safety devices, and the approval of plans for such materials, equipment, and devices. The fee so collected shall be deposited in the National Treasury to the credit of the Occupational Safety and Health Fund and shall be expended exclusively for the administration and enforcement of safety and other labor laws administered by the Department of Labor and Employment. Title II, Employees' Compensation and State Insurance Fund. Chapter 1, Policy and Definitions. 172, Policy. The state shall promote and develop a tax-exempt employees' compensation program whereby employees and their dependents, in the event of work-connected disability or death, may promptly secure adequate income benefit and medical-related benefits. 173. Definition of terms. As used in this title, unless the context indicates otherwise, A. Code means the Labor Code of the Philippines, instituted under Presidential Decree numbered 442 as amended. B. Commission means the Employees Compensation Commission created under this title. C. SSS means the Social Security System created under Republic Act numbered 1161 as amended. D. GSINs means the Government Service Insurance System created under Commonwealth Act numbered 186 as amended. E-System means the SSS or GSIS as the case may be. F. Employer means any person, natural or juridical, employing the services of the employee. G. Employee means any person compulsory covered by the GSIS under Commonwealth Act numbered 186 as amended, including the members of the Armed Forces of the Philippines and any person employed as casual, emergency, temporary, substitute or contractual, or any person compulsory covered by the SSS under Republic Act numbered 1161 as amended. D. H. Person means any individual, partnership, firm, association, trust, corporation, or legal representative thereof. I. Dependent means the legitimate, legitimated, or legally adopted or acknowledged natural child who is unmarried, not gainfully employed, and not over 21 years of age or over 21 years of age provided he is incapacitated and incapable of self-support due to a physical or mental defect which is congenital or acquired during minority. The legitimate spouse living with the employee and the parents of said employee wholly dependent upon him for regular support. J. Beneficiaries means the dependent spouse until he or she remarries and dependent children who are the primary beneficiaries. In their absence, the dependent parents and subject to the restrictions imposed on dependent children, the illegitimate children and legitimate descendants who are the secondary beneficiaries, provided that the dependent acknowledged natural child shall be considered as a primary beneficiary when there are no other dependent children who are qualified and eligible for monthly income benefit. K. Injury means any harmful change in the human organism from any accident arising out of and in the course of the employment. L. Sickness means any illness definitely accepted as an occupational disease listed by the Commission or any illness caused by employment subject to proof that the risk of contracting the same is increased by working conditions. For this purpose, the Commission is empowered to determine and approve occupational diseases and work-related illnesses that may be considered compensable based on peculiar hazards of employment. M. Death means loss of life resulting from injury or sickness. N. Disability means loss or impairment of a physical or mental function resulting from injury or sickness. O. Compensation means all payments made under this title for income benefits and medical or related benefits. P. Income benefit means all payments made under this title to the providers of medical care, rehabilitation services, and hospital care. Q. Medical benefit means all payments made under this title to the providers of medical care, rehabilitation services, and hospital care. R. Related benefit means all payments made under this title for appliances and supplies. S. Appliances means crutches, artificial aids, and other similar devices. T. Supplies means medicine and other medical, dental, or surgical items. Q. Hospital means any medical facility, government or private, authorized by law, an active member in good standing of the Philippine Hospital Association and accredited by the Commission. V. Physician means any doctor of medicine duly licensed to practice in the Philippines, an active member in good standing of the Philippine Medical Association and accredited by the Commission. W. Wages or salary insofar as they refer to the computation of benefits defined in Republic Act No. 1161 as amended for SSS and Presidential Decree No. 1146 as amended for GSIS respectively, except that part in excess of 3,000 pesos. X. Monthly salary credit means the wage or salary in Republic Act numbered 1161 as amended, or the wages or salary. Y. Average monthly salary credit in the case of the SSS means the result obtained by dividing the sum of the monthly salary credits in the 60-month period immediately following the semester of death or permanent disability by 60, except where the month of death or permanent disability falls within 18 calendar months from the month of coverage, in which case it is the result obtained by dividing the sum of all monthly salary credits paid prior to the month of contingency by the total number of calendar months of coverage in the same period. Z. Average daily salary credit in the case of the SSS means the result obtained by dividing the sum of the 6 highest monthly salary credits in the 12-month period immediately preceding the semester of sickness or injury by 180, except where the month of injury falls within 12 calendar months from the first month of coverage, in which case it is the result obtained by dividing the sum of all monthly salary credits by 30 times the number of calendar months of coverage in the period. In the case of the GSIS, the average daily salary credit shall be the actual daily salary or wage, or the monthly salary or wage divided by the actual number of working days of the month or contingency. AA. Quarter means a period of 3 consecutive months ending on the last days of March, June, September, and December. BB. Semester means a period of 2 consecutive quarters ending in the quarter of death, permanent disability, injury, or sickness. CC. Replacement ratio. The sum of 20% in the quotient obtained by dividing 300 by the sum of 340 in the average monthly salary credit. DD. Credited years of service. For a member covered prior to January 1975, 1975 minus the calendar year of coverage, plus the number of calendar years in which 6 or more contributions have been paid from January 1975 up to the calendar year containing the semester prior to the contingency. For a member covered on or after January 1975, the number of calendar years in which 6 or more contributions have been paid from the year of coverage up to the calendar year containing the semester prior to the contingency. EE. Monthly income benefit means the amount equivalent to 115% of the sum of the average monthly salary credit multiplied by the replacement ratio, and 1.5% of the average monthly salary credit for each credited year of service in excess of 10 years, provided that the monthly income benefit shall in no case be less than 250 pesos. Chapter 2. Coverage and Liability. 174. Compulsory coverage. Coverage in the State Insurance Fund shall be compulsory upon all employers and their employees not over 60 years of age, provided that employee who's over 60 years of age and paying contributions to qualify for the retirement or life insurance benefit administered by the system shall be subject to compulsory coverage. 175. Foreign employment. The Commission shall ensure adequate coverage of Filipino employees employed abroad, subject to regulations as it may prescribe. 176. Effective date of coverage. Compulsory coverage of the employer during the effectivity of this title shall take effect on the first day of his operation, and that of the employee on the date of his employment. 177. Registration. Each employer and his employees shall register with the system in accordance with its regulations. 178. Limitation of liability. The state insurance fund shall be liable for compensation to the employee or his dependents, except when the disability or death was occasioned by the employee's intoxication, willful intention to injure or kill himself or another, notorious negligence, or otherwise provided under this title. 179. Extent of liability. Unless otherwise provided, the liability of the state insurance fund under this title shall be exclusive and in place of all other liabilities of the employer to the employee, his dependents, or anyone otherwise entitled to receive damages on behalf of the employee or his dependents. The payment of compensation under this title shall not bar the recovery of benefits as provided for in Section 699 of the Revised Administrative Code, Republic Act numbered 1161 as amended, Republic Act numbered 4864 as amended, and other laws whose benefits are administered by the system or by other agencies of the government. 180. Liability of third party or parties. A. When a disability or death is caused by circumstances creating a legal liability against a third party, the disabled employee or the dependents, in case of his death, shall be paid by the system under this title. In case benefit is paid under this title, the system shall be subrogated to the rights of the disabled employee or the dependents in case of his death in accordance with the general law. B. Where the system recovers from such third-party damages in excess of those paid or allowed under this title, such excess shall be delivered to the disabled employee or other persons entitled thereto after deducting the cost of proceedings and expenses of the system. 181. Deprivation of the benefits. Except as otherwise provided under this title, no contract, regulation, or device whatsoever shall operate to deprive the employee or his dependents of any part of the income benefits and medical or related services granted under this title. Existing medical services being provided by the employer shall be maintained and continued to be enjoyed by their employees. Chapter 3. Administration. 182. Employees' Compensation Commission. A. To initiate, rationalize, and coordinate the policies of the Employees' Compensation Program, the Employees' Compensation Commission is hereby created to be composed of 5 ex officio members, namely, the Secretary of Labor and Employment as chairman, the GSI as General Manager, the SSS Administrator, the Chairman of the Philippine Medical Care Commission, and the Executive Director of the ECC Secretariat, and 2 appointive members, one of whom shall represent the employees and the other, the employers, to be appointed by the President of the Philippines for a term of 6 years. The appointive member shall have at least 5 years' experience in workmen's compensation or social security programs. All vacancies shall be filled for the unexpired term only. B. The Vice Chairman of the Commission shall be alternated each year between the GSI as General Manager and the SSS Administrator. The presence of 4 members shall constitute a quorum. Each member shall receive a per diem of 200 pesos for every meeting that is actually attended by him, exclusive of actual, ordinary, and necessary travel and representation expenses. In his absence, any member may designate an official of the institution he serves on full-time basis as his representative to act in his behalf. C. The general conduct of the operations and management functions of the GSIS or SSS under this title shall be vested in its respective chief executive officers, who shall be immediately responsible for carrying out the policies of the Commission. D. The Commission shall have the status and category of a government corporation, and it is hereby deemed attached to the Department of Labor and Employment for policy coordination and guidance. 183. Powers and duties. The Commission shall have the following powers and duties. A. To assess and fix a rate of contribution from all employers. B. To determine the rate of contribution payable by an employer whose records show a high frequency of work accidents or occupational diseases due to failure by the said employer to observe adequate safety measures. C. To approve rules and regulations governing the processing of claims and the settlement of disputes arising therefrom as prescribed by the system. D. To initiate policies and programs toward adequate occupational health and safety and accident prevention in the working environment, rehabilitation other than those provided for under Article 190 hereof, and other related programs and activities, and to appropriate funds therefore. E. To make the necessary actuarial studies and calculations concerning the grant of constant help and income benefits for permanent disability or death, in the rationalization of the benefits for permanent disability and death under the title with benefits payable by the system for similar contingencies, provided that the Commission may upgrade benefits and add new ones subject to approval of the President, and provided further that the actuarial stability of the State Insurance Fund shall be guaranteed. Provided, finally, that such increases in benefits shall not require any increases in contribution except as provided for in paragraph B hereof. F. To appoint the personnel of its staff subject to civil service and rules, but exempt from WAPCO law and regulations. G. To adopt annually a budget of expenditures of the Commission and its staff chargeable against the State Insurance Fund, provided that the SSS and GSIS shall advance on a quarterly basis the remittances of allotment of the loading fund for the Commission's operational expenses based on its annual budget, as duly approved by the Department of Budget and Management. H. To have the power to administer oath and affirmation and to issue subpoena and subpoena duces tectum in connection with any question or issue arising from appealed cases under this title. I. To sue and be sued in court. J. To acquire property, real or personal, which may be necessary or expedient for the attainment of the purposes of this title. K. To enter into agreements or contracts for such services and as may be needed for the proper, efficient, and stable administration of the program. L. To perform such other acts as it may deem appropriate for the attainment of the purposes of the Commission and proper enforcement of the provisions of this title. 184. Management of funds. All revenues collected by the system under this title shall be deposited, invested, administered, and disbursed in the same manner and under the same conditions, requirements, and safeguards as provided by Republic Act numbered 1161, as amended, with regard to such other funds as are thereunder being paid to or collected by the SSS and GSIS respectively, provided that the Commission, SSS, and GSIS may disburse each year not more than 12% of the contribution and investment earnings collected for operational expenses, including occupational health and safety programs incidental to the carrying out of this title. 185. Investment of funds. Provisions of existing laws to the contrary notwithstanding, all revenues as are not needed to meet current operational expenses under this title shall be accumulated in a fund to be known as the State Insurance Fund, which shall be used exclusively for payment of the benefits under this title, and no amount thereof shall be used for any other purpose. All amounts accruing to the State Insurance Fund, which is hereby established in the SSS and GSIS with any authorized depository bank approved by the Commission, or invested with true and prudent regard for the liquidity needs of the system. 186. Settlement of claims. The system shall have original exclusive jurisdiction to settle any dispute arising from this title with respect to coverage, entitlement to benefits, collection and payment of contributions and penalties thereon, or any other matter related thereto, subject to appeal to the Commission, which shall decide appeal cases within 20 working days from the submission of the evidence. 187. Review. Decisions, orders, or resolutions of the Commission may be reviewed on certiorari by the Supreme Court on question of law upon petition of an aggrieved party within 10 days from notice thereof. 188. Enforcement of decisions. A. Any decision, order, or resolution of the Commission shall become final and executory if no appeal is taken therefrom within 10 days from notice thereof. All awards granted by the Commission in cases appealed from decisions of the system shall be effected within 15 days from receipt of notice. B. In all other cases, decisions, orders, and resolutions of the Commission, which have become final and executory, shall be enforced and executed in the same manner as decisions of the Court of First Instance, and the Commission shall have the power to issue to the city or provincial sheriff or to the sheriff whom it may appoint such writs of execution as may be necessary for the enforcement of such decisions, orders, or resolutions, and any person who shall fail or refuse to comply therewith shall, upon application by the Commission, be punished by the proper court for contempt. Chapter 4. Contributions. 189. Employers' contributions. A. Under such regulations as the system may prescribe, beginning as of the last day of the month when an employee's compulsory coverage takes effect and every month thereafter during his employment, His employer shall prepare to remit to the system a contribution equivalent to 1% of his monthly salary credit. B. The rate of contribution shall be reviewed periodically and subject to the limitations herein provided, may be revised as the experience and risk, cost of administration, and actual or anticipated, as well as unexpected losses may require. C. Contributions under this title shall be paid in their entirety by the employer and any contract or device for the deductions of any portion thereof from the wages or salaries of the employees shall be null and void. D. When a covered employee dies, becomes disabled, or is separated from employment, his employer's obligation to pay the monthly contribution arising from that employment shall cease at the end of the month of contingency and during such months that he is not receiving wages or salary. 190. Government Guarantee. The Republic of the Philippines guarantees the benefits prescribed under this title and accepts general responsibility for the solvency of the State Insurance Fund. In case of any deficiency, the same shall be covered by supplemental appropriations from the national government. Chapter 5 Medical Benefits 191 Medical Services. Immediately after an employee contracts sickness or sustains an injury, he shall be provided by the system during the subsequent period of his disability with such medical services and appliances as the nature of his sickness or injury and progress of his recovery may require, subject to the expense limitation prescribed by the Commission. 192 Liability. The system shall have the authority to choose or order a change of physician, hospital, or rehabilitation facility for the employee and shall not be liable for compensation for any aggravation of the employee's injury or sickness resulting from unauthorized changes by the employee of medical services, appliances, supplies, hospitals, rehabilitation facilities, or physicians. 190. Attending Physician. Any physician attending an injured or sick employee shall comply with all the regulations of the system and submit reports in prescribed forms at such time as may be required concerning his condition or treatment. All medical information relevant to the particular injury or sickness shall, on demand, be made available to the employee or the system. No information developed in connection with treatment or examination for which compensation is sought shall be considered as privileged communication. 194. Refusal of examination or treatment. If the employee unreasonably refuses to submit to medical examination or treatment, the system shall stop the payment of further compensation during such time as such refusal continues. What constitutes an unreasonable refusal shall be determined by the system, which may, on its own initiative, determine the necessity, character, and sufficiency of any medical services furnished or to be furnished. 195. Fees and other charges. Hospital services, medical care, and appliances fees shall not be higher than those prevailing in wards of hospitals for similar services to injured or sick persons in general, and shall be subject to the regulations of the Commission. Professional fees shall only be appreciably higher than those prescribed under Republic Act numbered 6111 as amended, otherwise known as the Philippine Medical Care Act of 1969. 196. Rehabilitation Services. A. The system shall, as soon as practicable, establish a continuing program for the rehabilitation of injured and handicapped employees who shall be entitled to rehabilitation services, which shall consist of medical, surgical, or hospital treatment, including appliances if they have been handicapped by the injury to help them become physically independent. B. As soon as practicable, the system shall establish centers equipped and staffed to provide a balanced program of remedial treatment, vocational assessment, and preparation designed to meet the individual needs of each handicapped employee to restore him to suitable employment, including assistance as may be within its resources, to help each rehabilitee to develop his mental, vocational, or social potential. Chapter 6 Disability Benefits 197 Temporary Total Disability 197 Temporal total disability. A. Under such regulations as the Commission may approve, any employee under this title who sustains an injury or contracts sickness resulting in temporary total disability shall, for each day of such a disability or fraction thereof, be paid by the system an income benefit equivalent to 90% of his average daily salary credit, subject to the following conditions. The daily income benefit shall not be less than 10 pesos, nor more than 90 pesos, nor paid for a continuous period longer than 120 days, except as otherwise provided for in the rules, and the system shall be notified of the injury or sickness. B. The payment of such income benefits shall be in accordance with the regulations of the Commission. 198. Permanent total disability. A. Under such regulations as the Commission may approve, any employee under this title who contracts sickness or sustains an injury resulting in his permanent total disability shall, for each month until his death, be paid by the system during such a disability an amount equivalent to the monthly income benefit plus 10% thereof for each dependent child, but not exceeding 5, beginning with the youngest and without substitution, provided that the monthly income benefit shall be the new amount of the monthly benefit for all covered pensioners, effective upon approval of this decree. B. The monthly income benefit shall be guaranteed for 5 years and shall be suspended if the employee is gainfully employed or recovers from his permanent total disability or fails to present himself for examination at least once a year upon notice by the system, except as otherwise provided for in other laws, decrees, orders, or letters of instructions. C. The following disabilities shall be deemed total and permanent. 1. Temporary total disability lasting continuously for more than 120 days, except as otherwise provided for in the rules. 2. Complete loss of sight of both eyes. 3. Loss of two limbs or above the ankle or wrist. 4. Permanent complete paralysis of two limbs. 5. Brain injury resulting in incurable imbecility or insanity, and 6. Such cases as determined by the medical director of the system and approved by the Commission. D. The number of months of paid coverage shall be defined and approximated by a formula to be approved by the Commission. 199. Permanent partial disability. A. Under such regulations as the Commission may approve, any employee under this title who contracts sickness or sustains an injury resulting in permanent partial disability shall, for each month not exceeding the period designated herein, be paid by the system during such a disability and income benefit for permanent total disability. B. B. The benefit shall be paid for not more than the period designated in the following schedules: complete and permanent loss of the use of one thumb, number of months 10, one index finger 8, one middle finger 6, one ring finger 5, one little finger 3, one big toe 6, one arm 50, one hand 39, one foot 31, one leg 46, one ear 10, both ears 50, sight of one eye 25. C. A loss of a wrist shall be considered as a loss of the hand, and a loss of an elbow shall be considered as a loss of the arm. A loss of an ankle shall be considered as a loss of a foot, and a loss of a knee shall be considered as a loss of the leg. A loss of more than one joint shall be considered as a loss of one half of the whole finger or toe, provided that such a loss shall be either the functional loss of the use or physical loss of the member. D. In case of permanent partial disability less than the total loss of the member specified in the preceding paragraph, the same monthly income benefit shall be paid for a portion of the period established for the total loss of the member in accordance with the proportion that the partial loss bears to the total loss. If the result is a decimal fraction, the same shall be rounded off to the next higher integer. E. In cases of simultaneous loss of more than one member or a part thereof, as specified in this article, the same monthly income benefit shall be paid for a period equivalent to the sum of the periods established for the loss of the member or the part thereof. If the result is a decimal fraction, the same shall be rounded off to the next higher integer. F. In cases of injuries or illnesses resulting in a permanent partial disability not listed in the preceding schedule, the benefit shall be an income benefit equivalent to the percentage of the permanent loss of the capacity to work. G. Under such regulations as the Commission may approve, the income benefit payable in case of permanent partial disability may be paid in monthly pension or in lump sum if the period covered does not exceed 1 year. Chapter 7, Death Benefits. Article 200, Death. A. Under such regulations as the Commission may approve, the system shall pay to the primary beneficiaries upon the death of the covered employee under this title an amount equivalent to his monthly income benefit plus 10% thereof for each dependent child, but not exceeding 5, beginning with the youngest and without substitution, except as provided for in paragraph J of Article 167 hereof, provided, however, that the monthly income benefit shall be guaranteed for 5 years, provided further that if he has no primary beneficiary, the system shall pay to his secondary beneficiaries the monthly income benefit, but not to exceed 60 months, provided finally that the minimum death benefit shall not be less than 15,000 pesos. B. Under such regulations as the Commission may approve, the system shall pay to the primary beneficiaries upon the death of a covered employee who is under permanent total disability under this title 80% of the monthly income benefit and his dependents to the dependent's pension, provided that the marriage must have been validly subsisting at the time of disability, provided further that if he has no primary beneficiary, the system shall pay to his secondary beneficiaries the monthly pension excluding the dependent's pension of the remaining balance of the 5-year guaranteed period, provided finally that the minimum death benefit shall not be less than 15,000 pesos. C. The monthly income benefit provided herein shall be the new amount of the monthly income benefit for the surviving beneficiaries upon the approval of this decree. D. Funeral benefit. A funeral benefit of 3,000 pesos shall be paid upon the death of a covered employee or permanently totally disabled pensioner. Chapter 8. Provisions common to income benefits. Article 201. Relationship and dependency. All questions of relationship and dependency shall be determined as of the time of death. 202. Delinquent contributions. A. An employer who is delinquent in his contributions shall be liable to the system for the benefits which may have been paid by the system to his employees or their dependents, and any benefit and expenses to which such employer is liable shall constitute a lien on all his property, real or personal, which is hereby declared to be preferred to any credit, except taxes. The payment by the employer of the lump sum equivalent of such liability shall absolve him from the payment of the delinquent contribution and penalty thereon with respect to the employee concerned. B. Failure or refusal of the employer to pay or remit the contribution herein prescribed shall not prejudice the right of the employee or his dependents to the benefits under this title. If the sickness, injury, disability, or death occurs before the system receives any report of the name of his employee, the employer shall be liable to the system for the lump sum equivalent to the benefits to which such employee or his dependents may be entitled. 203. Second injuries. If any employee under permanent partial disability suffers another injury which results in a compensable disability greater than the previous injury, the state insurance fund shall be liable for the income benefit of the new disability, provided that if the new disability is related to the previous disability, the system shall be liable only for the difference in income benefits. 204. Assignment of benefits. No claim for compensation under this title is transferable or liable to tax, attachment, garnishment, levy, or seizure, buyer under any legal process whatsoever, either before or after receipt by the person or persons entitled thereto, except to pay any debt of the employee to the system. 205. Earned benefits. Income benefits shall, with respect to any period of disability, be payable in accordance with this title to an employee who is entitled to receive wages, salaries, or allowances for holidays, vacation, or sick leaves, and any other award of benefit under a collective bargaining or other agreement. 206. Safety devices. In case the employee's injury or death was due to the failure of the employer to comply with any law or to install and maintain safety devices or to take other precautions for the prevention of injury, said employer shall pay the state insurance fund a penalty of 25% of the lump sum equivalent of the income benefit payable by the system to the employee. All employers, especially those who should have been paying a rate of contribution higher than required of them under this title, are enjoined to undertake and strengthen measures for the occupational health and safety of their employees. 207. Prescriptive period. No claim for compensation shall be given due course unless said claim is filed with the system within 3 years from the time the cause of action accrued. 208. Erroneous payment. A. If the system in good faith pays income benefit to a dependent who is inferior in right to another dependent or with whom another dependent is entitled to share, such payments shall discharge the system from liability unless and until such other dependent notifies the system of his claim prior to the payments. B. In case of doubt as to the respective rights of rival claimants, the system is hereby empowered to determine as to whom payments should be made in accordance with such regulations as the Commission may approve. If the money is payable to a minor or incompetent, payment shall be made by the system to such person or persons as it may consider to be best qualified to take care and dispose of the minor's or incompetent's property for his benefit. 209. Prohibition. No agent, attorney, or other person pursuing or in charge of the preparation or filing of any claim for benefit under this title shall demand or charge for his services any fee, and any stipulation to the contrary shall be null and void. The retention or deduction of any amount from any benefit granted under this title for the payment of fees for such services is prohibited. Violation of any provision of this article shall be punished by a fine of not less than 500 pesos nor more than 5,000 pesos, or imprisonment for not less than 6 months nor more than 1 year, or both at the discretion of the court. 210. Exemption from levy, tax, etc. All laws to the contrary notwithstanding, the State Insurance Fund and all its assets shall be exempt from any tax, fee, charge, levy, or customs or import duty, and no law hereafter enacted shall apply to the State Insurance Fund unless it is provided therein that the same is applicable by expressly stating its name. Chapter 9. Records, Reports, and Penal Provisions. 211. Record of Death or Disability. A. All employers shall keep a logbook to record chronologically the sickness, injury, or death of their employees, setting forth therein their names, dates, and places of the contingency, nature of the contingency, and absences. Entries in the logbook shall be made within 5 days from notice or knowledge of the occurrence of the contingency. Within 5 days after entry in the logbook, the employer shall report to the system only those contingencies he deems to be work-connected. B. All entries in the employer's logbook shall be made by the employer or any of his authorized official after verification of the contingencies or the employee's absences for a period of a day or more. Upon request by the system, the employer shall furnish the necessary certificate regarding information about any contingency appearing in the logbook, citing the entry number, page number, and date. Such logbook shall be made available for inspection to the duly authorized representative of the system. C. Should any employer fail to record in the logbook an actual sickness, injury, or death of any of his employees within the period prescribed herein, give false information, or withhold material information already in his possession, he shall be held liable for 50% of the lump sum equivalent of the income benefit to which the employee may be found to be entitled, the payment of which shall accrue to the State Insurance Fund. D. In case of payment of benefits for any claim which is later determined to be fraudulent and the employer is found to be a party to the fraud, such employer shall reimburse the system the full amount of the compensation paid. 212. Notice of sickness, injury, or death. Notice of sickness, injury, or death shall be given to the employer by the employee or by his dependents or anybody on his behalf within 5 days from the occurrence of the contingency. No notice to the employer shall be required if the contingency is known to the employer or his agents or representatives. 213. Penal Provisions. A. The penal provisions of Republic Act numbered 1161 as amended and Commonwealth Act numbered 186 as amended with regard to the funds as are thereunder being paid to, collected, or disbursed by the system shall be applicable to the collection, administration, and disbursement of the funds under this title. The penal provisions on coverage shall also be applicable. B. Any person who, for the purpose of securing entitlement to any benefit or payment under this title, or the issuance of any certificate or document for any purpose connected with this title, whether for him or for some other person, commits fraud, collusion, falsification, misrepresentation of facts, or any other kind of anomaly, shall be punished with a fine of not less than 500 pesos, nor more than 5,000 pesos, and an imprisonment for not less than 6 months nor more than 1 year at the discretion of the court. C. If the act penalized by this article is committed by any person who has been or is employed by the Commission or system, or a recidivist, the imprisonment shall not be less than 1 year. If committed by a lawyer, physician, or other professional, he shall, in addition to the penalty prescribed herein, be disqualified from the practice of his profession, and if committed by any official, employee, or personnel of the Commission, system, or any government agency, he shall, in addition to the penalty prescribed herein, be dismissed with prejudice to reemployment in the government service. 214. Applicability. This title shall apply only to injury, sickness, disability, or death occurring on or after January 1, 1975. 215. Repeal. All existing laws, presidential decrees, and letters of instructions which are inconsistent with or contrary to this decree are hereby repealed, provided that in the case of the GSIS, conditions for entitlement to benefits shall be governed by the Labor Code as amended, provided, however, that the formulas for computation of benefits as well as the contribution base shall be those provided under Commonwealth Act numbered 1186 as amended by Presidential Decree number 1146 plus 20% thereof. Title 3 Medicare 216 Medical Care. The Philippine Medical Care Plan shall be implemented as provided under Republic Act number 6111 as amended. Title 4 Adult Education 217 Adult Education. Every employer shall render assistance in the establishment and operation of adult education programs for their workers and employees as prescribed